Hello, welcome. I'm Ruth Marcus, Deputy Editorial Page Editor and columnist for the Washington Post. Thank you all for being here. We're focusing today on how First Amendment issues are playing out on college campuses, in the courts, and as you saw, maybe even sometimes on the football field. You can join the conversation in the room and online by tweeting questions using the hashtag #Free2State. Our guests include two advocates for free speech, Susan Herman, president of the American Civil Liberties Union, and Suzanne Nossel, chief executive of the nonprofit PEN America. But we're going to begin today with the third highest ranking leader of the Justice Department, Acting Associate Attorney General Jesse Panuccio. He oversees many things: the Antitrust Division, the Civil Division, the Civil Rights Division, the Environmental and Natural Resources Division, and more. So thank you very much to all of you for coming. General Panuccio, we are going to get, I promise you, to all the deliciously interesting, not just about cakes, on deliciousness, First Amendment issues. But I want to start with something else that is under your purview as the head of the overseer of the Civil Division, and that's in the news today, which is the family separation policy that the administration has implemented. There was a decision last week from actually a federal judge appointed by George W. Bush in a lawsuit brought by the American Civil Liberties Union challenging the family separation policy. And here's what the judge had to say. These allegations sufficiently describe government conduct that arbitrarily tears at the sacred bond between parent and child. Such conduct, if true, is brutal, offensive, and fails to comport with traditional notions of fair play and decency. As the overseer of the Civil Division, it's going to fall to you to defend the government's policy in court. What is the defense for the policy, and are you comfortable defending it?
So thank you, first of all. It's a pleasure to be here. Appreciate the Washington Post and all the sponsors having us to talk about the First Amendment, which I know we're going to get to. But you have to ask. That is a matter, as you say, that's in active litigation, and two of the parties are on stage. So as is typical with something that we're a party to in active litigation, still reviewing that decision and formulating briefs. I'm going to let our briefs do the talking on it and leave it there.
Well, are you comfortable defending the policy?
Well, we're defending in court now, and we'll continue to defend.
All right.
Yes.
We will keep an eye on that, and meanwhile, we'll keep an eye on the First Amendment. You just intervened, a kind of unusual, but part of a series of interventions that the Justice Department has done involving litigation on campus free speech. Not a normal issue for the Justice Department. Tell us, the latest intervention involved the University of Michigan. Tell us why, of all the array of important legal issues in all the federal courts in the country, it makes sense for the Justice Department to devote its resources to this issue.
Well, that's a great question. We're doing many things at once, of course, but this is the First Amendment. It's our first freedom in the Constitution. And you heard at the beginning there was an opening clip there, that speech from the Attorney General, where he said he thinks there is a crisis on the American campus of respect for First Amendment values. And you've seen many clips in the news of not only speakers getting shouted down, but instances with professors and students. And so he felt, and we all feel at the department, that not only our bully pulpit at the department to talk about First Amendment values, but inappropriate cases where we think a public state-run university has a policy or a practice that is not consistent with the First Amendment, to go into court and state that view. And many times it's important. The Civil Rights Division files statements of interest in many different kinds of cases dealing with civil rights. First Amendment is such a right. And so we think lending our voice to that matters quite a bit.
So some people would look at your intervention and say, aha, you're concerned about free speech when it's conservatives who are being shouted down. Give us your response to that.
I reject that.
I'm so shocked.
Some of these instances, I mean, look, let's be honest about what's going on campus. Conservative voices typically are not a majority voice on campus, so some of these instances involve conservative voices, but not always. I mean, if you look at the Michigan case, what we filed our statement of interest there is about a policy. That policy applies to everybody. And that policy said, your speech can be punished if it is offensive, and the way they define, or biased. And the way they said the most important indication of bias is how you feel, how the listener feels. So anyone that, if it's conservative speech and a liberal is offended, they might say, well, that's bias, or vice versa. So it is not true that these cases involve students or speakers of only one political stripe, and we'll get involved in any case where we think the First Amendment is implicated and violated.
And I know it's not necessarily a First Amendment issue because with the NFL, it's a private party that's implementing its own rules about protests on football fields. But the President of the United States, who is a government official, has spoken out very vociferously against football players who either choose to kneel or choose to absent themselves, as the NFL new policy will allow. You said pretty recently, there's now this idea on college campuses that if you hear speech that's offensive to you, you can't deal with it in any other way than by shutting it down. That's not a very good lesson to be teaching, and it's not the lesson of our First Amendment. The president has said if the football players don't like the pledge and don't like the national anthem, maybe they should just leave the country. Why is he sending, explain to us how he is sending a message to football players on their protests that's consistent with the First Amendment?
Well, let me try to address two parts of that. So college campuses, first of all, when we file these statements of interest, they are in cases where they are state-run universities where you have government actors who the First Amendment applies. On private campuses, although we may not think it's a good pedagogical method to shut down speech or only allow one viewpoint, you could certainly imagine a campus, a religious school, for example, that wants to teach certain doctrine, and so they funnel speech, and they're allowed to do that as private actors. Public actors are not. Now, the NFL, as you say...
Can I just interrupt you for 1 second there? Wouldn't your position also apply to private universities that accept federal funding?
Well, it depends what conditions there are in the federal funding. So, that might be a question of the specific funds that are at issue. But writ large, state actors, the First Amendment absolutely applies. And so those are the most basic cases. When you get into funding, it really depends what conditions are on the funding. But to go back to your earlier question, the NFL and the players are private entities, and so they can engage in a debate. The owners and the players can have a debate. And as for the President of the United States or any other government official, they have a bully pulpit. They're allowed to, as politicians and as leaders of the country, express a view. And let's face it, these protests, the kneeling, it is about public issues. And so the whole point is to engage in a debate over those issues.
On the one hand, the government expresses enormous solicitude for free speech through the intervention that you did. On the other hand, the president doesn't seem to have such solicitude for free speech in his tolerance or lack thereof of the NFL players.
I think he's engaging in the debate. That's what's going on here. Is there is a debate about what it is like to, whether you should stand for the flag, whether you shouldn't, whether that's an appropriate place, what message are you sending? And so there's a message and a counter message, and that's the whole point of the First Amendment, is we have a robust exchange of ideas, and sometimes they're joined very sharply, but that's what we want in this country.
Suzanne,
yeah,
you
sure.
looked like you wanted to jump in there.
Well, it's hard not to. I think, I think it would be one thing if this was just a matter of political speech, but I think the president has made clear through his relationships, the owners, that he wants to see players benched and punished. He's called them sons of bitches. I mean, this is from the president of the United States. So, I think that the fact that we've seen players who have been punished, whose careers perhaps have been ruined, as a result of the president's threats and rhetoric and intervention to punish speech is alarming. I mean, to me, it's one step removed, but it certainly implicates the First Amendment when the president goes after protected acts of political speech, which these unquestionably are. There have also been cases on campus, for example, at Kennesaw State, the cheerleaders who took a knee, and then were taken off the field. That's a public university. So, I'd be interested in seeing the Justice Department intervene in support of those cheerleaders' rights. I think some of the points you've made in your briefs where you have intervened are very valid, and they're genuine concerns about free speech on campus, but it's extremely important that the Justice Department show an even-handed approach and intervene equally in cases coming from the suppression of speech from the right and the left, and that's not what we see so far. I think there's another element that has to be brought in here, which is the broader climate of civil rights enforcement and what we see on campus. The campus population already is where the rest of the United States population is going. There's no single racial or ethnic majority population among American students. We see an increasingly demographically diverse student population. They're asking for new kinds of changes and demands on campus, new respect for whether it's nomenclature, pronouns, how LGBT and transgender students are treated, further progress in racial equality on campus. And I think it's extremely important that the Justice Department be active in its role in enforcing a equal educational environment. If it's free speech but a pullback on civil rights protections and enforcement, I think we're going to reinforce the idea that the First Amendment's not for everybody. We already hear that in our work on campus free speech. Students who are alienated from the First Amendment, who say, First Amendment wasn't written for me. The only time they see it as invoked is to protect speech that offends and targets them. I think there's a very real risk we run that the First Amendment comes to be seen as associated with a particular political agenda, and it's crucially important that you defend a campus that is open both to all ideas and to all people.
So if I could agree with a lot of what Suzanne was saying, I'd also like to broaden the conversation since we're the first panel on the First Amendment. I think there's a widespread misunderstanding and lack of appreciation for the First Amendment on all sides of the political spectrum. First of all, as Jesse was saying, a lot of people are not aware that the NFL cannot violate the First Amendment because it's not a governmental actor. On the other hand, a public university does violate the First Amendment if they punish students, as they have for student athletes for taking the knee during the Star-Spangled Banner, or if they punish conservative students. We agree with that. The ACLU's bedrock principle is we are content neutral about speech, and we believe that universities should be as well. Another place where there's been a tremendous amount of punishment of student political expression is on Israeli boycotts. There have been quite a number of schools that have prohibited activities or whatever. So it seems to me, I agree with Suzanne, that I would hope that the government would be neutral, content neutral about defending everyone's right to speech. I also want to follow up on this idea of the whole idea that there's a zero-sum game between speech and equality, which is just not true. The ACLU wholeheartedly defends both. We think students have a right under federal civil rights laws not to be bullied and harassed, and we also believe that people should have the right to express their political views. And there are a lot of ways in which those two things, I think, support each other. And the idea that so many students think, in a recent poll, college students said that they prefer equality to liberty. Now, you can mock that as political correctness and say it's just about words, but what I think it is, I think it's coming from a very deep place of empathy, that students understand that if the University of Michigan has a population of African-American students, 5%. And I think students understand that if you have a climate of racial slurs and et cetera, that's uncomfortable. And I think we have to find ways, instead of having people each in their own echo chamber talking about my conservative speech and my right and my equality, we have to get people talking to each other. And it seems to me the primary job of schools right now should be not to censor and eliminate and prohibit people from talking about a subject, but to get people to talk to each other and to have people who may have a right to make a racist joke understand why it's not a good idea, and to make students who want not to have a conservative speaker on campus understand that it's a much better idea to have them on campus and to think through their arguments and where they disagree.
Well, there's a lot to respond to there, but can you imagine a world in which the Sessions Justice Department, the President Trump Justice Department, goes to a public university and says, you can't discipline your students, your football players, your cheerleaders for taking a knee?
I can imagine a world in which the Justice Department stands up for the First Amendment regardless of political philosophy or the particular viewpoint that is being expressed. Now, every factual situation is different, so if you're on a team, on a squad, is that you have to look at whether it's a public forum and all of those things, and that's why we analyze each case. But as we've said since we started this initiative, we will get involved in any case where we think the First Amendment is being violated. And I will tell you, if you look at our Michigan filing, just to respond to what was just said, it absolutely is true. Schools have requirements under law, and also just as good stewards of their campus, to make sure that they have anti-harassment and anti-bullying policies. But there is well-trodden legal ground about when that deals with true harassment or it goes over into chilling protected speech. And I'll give you credit. If you look at the ACLU's website, they have a page. I looked at it last night on campus speech. It lays this out very well about the difference between creating an appropriate learning environment for students while also allowing the robust free exchange of ideas. And there is a balance there, but it's one we've traditionally been able to strike on campuses, but one that seems in recent years to be waning, unfortunately.
I think there's something else that's got to come into it, which is, one of the reasons I think the balance is tipping is that we have seen a significant upsurge in white supremacist activity on campus, in incidents of hate speech and hate crimes on campus. And I think that's because, or at least in substantial part, because of this kind of enabling environment for hatred that we see in the current administration, with the Muslim ban, with the attacks on transgender troops in the military, now what's happening at the border, immigrant children, DACA students feeling particularly vulnerable and targeted and exposed. And so that has led to, sort of a paradox in a sense, because it's led to this upsurge in hateful speech on campus and a sense of, of kind of a more substantiated victimization. I mean, you could say a couple of years ago, this was, a kind of coddling of students, but the environment has become significantly more both physically dangerous and treacherous for certain students, certainly DACA students. And so that has strengthened these calls to curtail speech, which we oppose. But the work of opposing them has become more difficult because of this enabling environment for hate speech. And I think that's something that the administration has to take on.
If I could go beyond campus for a minute, it seems to me that the whole idea of safe spaces is something that is part of our partisan atmosphere today. We have such a hyper-partisan atmosphere that I think students are afraid of ideas that they don't agree with. They don't know what to do with them. So let me give you an example that has nothing to do with the federal government, but in DC, since that's where we are, the ACLU has a lawsuit against the Transit Authority for literally banning the First Amendment. We wanted to take out an ad running the language of the First Amendment. It was something that we had displayed in Times Square, and it's the text of the First Amendment in English, in Spanish, and Arabic, and underneath it says the Constitution is for everyone. And the Transit Authority refused to allow us to put up that ad because their policy is that you're not allowed to post ads that are intended to influence public debate. Now, what is not intended to influence public debate? So following up on that, that lawsuit was pending when the ACLU last week had an enormous membership conference in Washington, D.C., and the MTA would not run our ad for the conference. The only text on that was, "You belong here." Totally innocuous ad. They finally ended up allowing us to put it at bus shelters.
I saw it in the bus shelter.
Yeah, on the bus shelter, but not in the subway. Okay, and so that to me, that's like, the safe space. Everyone is afraid of everyone else's ideas. And I think we have to learn to talk to each other to figure out what fundamental values we still have in common.
So this is a terrible segue, I'm going to admit it. But
you're entitled.
On the question of talking to each other, one question has to do with our work as journalists and the surveillance that's gone on and the potential prosecution that's looming of our work as journalists, and as the government goes after leakers, the surveillance that has occurred of a colleague of ours at the New York Times, whether it was when she was at the New York Times or at earlier things, is how do you, in the robust defense of the First Amendment, how do you think about how the government should deal with surveillance of subpoenas for other information seeking of journalists' work? And I know you had also, Suzanne, had some interest in the question of Ali Watkins.
Okay. Well, I'll say two things about that just to preface this. One, ongoing criminal cases not on my side of the house in terms of what I manage, and two, obviously can't talk about any pending prosecution. I can say more generally, when you're thinking about the intersection of First Amendment and criminal law, or any provision of the Bill of Rights and criminal law, of course, the Bill of Rights is not a refuge from criminal law, and so a properly enacted, upheld constitutional criminal law is still applicable, even if it implicates something like speech or any of the other protected rights. And so finding that balance is always something the Justice Department strives to do and has policies in place to do that.
You know, I think we're at a very dangerous moment in terms of press freedom in this country. We have, out of the White House, a relentless drumbeat of verbal attacks on the press. We have a deliberate effort to discredit credible news sources like the Washington Post. I think at some level we'd all agree are engaged in the business of serious news to conflate fake, genuine and fraudulent news, to amplify lies that are published and shared on social media, and to threaten the press in very concrete ways. And so I think everything the administration does has to be seen in that context. It's, to me, it's unprecedented. It's clear. It's distorting public discourse. There are many people who cannot sort fact from fiction, and it's a very dangerous moment, I think, in terms of the role of truth in our society. In that context, we now have this case with this very far-reaching examination of a journalist's personal, the metadata of her personal communications going back to her time as an undergraduate, and that's got to have a chilling effect. We all know that. It includes encrypted communications, we think. So how can any journalist now go about their work, not worrying about the possibility that, they too, if they're in contact with sensitive sources, may be, unbeknownst to them, the subject of a similar kind of investigation where their metadata and communications are being seized and examined. So I think it's very worrying. I mean, it's a complicated case. It's not a clean case by any means, and I think that the news organizations are responding appropriately in light of that. But I think as citizens who depend on media outlets for our information and our ability to play our role as citizens, I think this is worrying.
And I think that's another place, too, where I think people don't appreciate the First Amendment as much as they used to. Marty Barron quoted James Madison, so I'll quote Thomas Jefferson, who once said, if I had to choose between government without a free press or free press without a government, I would not hesitate to choose the latter. So I think you undermine the media by calling it all fake news and getting people not to pay attention to journalistic standards and where people are in fact checking the truth. I think it's not just about the First Amendment. I think it's about whether or not we're going to have an effective democracy.
So another bad segue. I'm going to segue to another part of the First Amendment, which is the religion clauses. We just had this fascinating, perhaps not the last ruling in the Masterpiece Cake Shop case. I'm wondering where you see this conversation going now. And I'm also going to ask the question in a little bit more of a challenging way. The other day, the Attorney General was citing the Apostle Paul on the command to obey the laws of government because God has ordained the government for his purposes. Orderly laws and lawful processes are good in themselves. Why doesn't it make sense then for a baker to obey the laws of the state of Colorado that he should serve same-sex couples equally with straight couples?
Well, there's a lot to that question. To step back a little bit in that case, I guess to answer the last part of it, the question is, what is the law under the Supremacy Clause? If you have a First Amendment right to do something in a state law, this is what we're talking about on college campuses, a state law contravenes that, of course, it is not the law. The First Amendment is the law. So I think that answers that piece of it. More generally, in that case, it was ultimately decided on religion clause grounds and not on speech grounds. Sure. The Justice Department filed a brief that addressed the speech issue, and in two of the concurring opinions, I believe Justice Gorsuch and Justice Thomas both addressed that. And what it really boils down to in that particular speech question and what kind of First Amendment scrutiny is triggered is, what is expressive activity? Do you view the baking of a cake or a custom cake as expressive activity? And those can be very difficult questions. There have been many famous and noteworthy cases over the years where nonverbal action has been held to be expressive conduct. The ACLU has been involved in many of those cases over the years. And so those are hard and difficult questions as we balance things like public accommodation laws with the right to speak and what is expressive activity.
Can I disagree with your characterization of the case? I think it's perfectly clear what the law is about the First Amendment and has been since at least 1990. And the law is that religion cannot be an excuse for refusing to comply with an otherwise neutral law, including anti-discrimination laws. People made religious arguments for why they didn't have to have racial integration. People made religious arguments for why they didn't have to pay women an equal wage. And Justice Kennedy, in his opinion, is perfectly clear that he is not questioning those precedents. What the court did not decide in Masterpiece Cake Shop was they did not decide that there was a First Amendment right of expression claim on the part of the baker. They just really, that was just not in the case, and I think that that's very telling. What Justice Kennedy did decide, and this seems to me to be very typical of his previous jurisprudence, was that you can't have animus against people for, for their religion any more than for their sexuality or anything else. And so what troubled him was the fact that it just very particular to the facts of this case, that several people, on the, at least one, on the Colorado Commission for Human Rights, Civil Rights, made insulting remarks about religion, and that it seemed to be a kind of ad hominem, not personally, but there was animus behind that decision. And what Justice Kennedy says is it's not appropriate for any form of government to have animus against anybody, whether it's that they're gay or that they're religious. So it seems to me that Masterpiece Cake Shop completely upholds our position that the Colorado Civil Rights Commission would have the right to make the same decision in another case. The other thing about the case was that Justice Kennedy situated the case in a time before Colorado recognized same-sex marriage. And so there might have been some ambiguity at that time. There no longer is. So while I think Masterpiece Cake Shop is a great disappointment for the ACLU's clients, David Mullins and Charlie Craig, because they were not vindicated, we think that the case is perfectly clear about what First Amendment law is and that where the court is going on that.
We're getting a little bit short on time here. I'm going to do one Twitter question and then a final question. Caitlin on Twitter asks, and it's an important question, does the potential for substantial disruption, particularly violence from protesters, change what speech is protected on campus? How should we think about that? Kind of lightning round-ish.
You know, I really don't think it does. I think it's very important. I mean, people kind of can misconstrue the concept of incitement. You know, incitement to imminent violence is one of the categories of speech that can be restricted under our law. But incitement means me encouraging them to go and commit an act of violence. It isn't me saying something so provocative that Jesse wants to punch me in the nose. And so even if I,
I'm the one who wants to punch.
No.
So I think it, you know, it is, if speech is still protected, even if it might elicit a violent reaction. You know, this is one of the things that's come under debate because universities have to spend a lot of money at times to secure events by highly controversial speakers. And, you know, our view is, yeah, they need to spend the money. The best thing is to have the person come. You can send a message about how the substance of their speech may be inimical to the values of the university, and it can be important for the university leadership to speak out. But it's better to let a Richard Spencer or Milo Yiannopoulos, if they insist on coming to campus, they have a valid invitation, often from a student group. It's better to let them come, have their moment, let the protest proceed, but without disrupting their speech. And then they don't get the validation. They can't sue. They don't get to grandstand. And, you know, the moment passes. And I think that's actually where we are now. And a number of universities, including the University of Florida, have approached it in that way. And I think some of the kind of venom has begun to come out of that particular issue. So, you know, my view is clear that, you know, the potential for violence is not grounds for shutting down speech. You know, there can become a threshold where an event cannot be secured, absolutely cannot be secured, you know, with the most serious precautions possible, and that might be a different instance, but that's very rare.
And are you worried from your end that about shutting down speech of protesters and chilling them, because you've talked a little bit about the heckler's veto and the risks there?
So the heckler's veto is another, and in one of our briefs we talk about this. If a school allows, say, a violent protest to shut down speech, that can be problematic and it can become violative of the First Amendment. But peaceful protest, or protest that doesn't become a crime, it doesn't go to violence, is valid exercise of speech, and so you have to allow spaces for that protest. The question is whether the protesters ought to be allowed, if they didn't like the four of us on stage here today, if everybody got up and simply shut us down, that would become a problem if it was on a university and that were allowed. So there's always a balance there, but I mean, I think generally the answer to speech you don't like is more speech, and if it does become violent, though, of course, we have a much greater problem.
They're going to shut us down pretty soon, so I'm going to squeeze in one last question, which is, you're the acting number 3 official at the Justice Department. I covered the Justice Department many years ago. It would be fun to be back covering it today, because we have the phenomenon of an Attorney General who is regularly rebuked, reviled, criticized on Twitter and elsewhere by the President of the United States. First of all, what's that like, working at the Justice Department? And second of all, if something happens, are you ready to step in as Attorney General? Has that come up at all?
So, Ruth, there's 35 seconds left.
No, it's okay. You can go over.
I bet you I can filibuster right to the end of this thing.
I bet you could. I
am a lawyer, after all.
Can't see pending litigation. Can't get out of it that way.
Look, I'll just say this. It's the honor of a lifetime to be able to work at the Justice Department. Many lawyers would tell you that it is something they want to do, and many people in either administrations of either party try to do that. So I'm proud to be there. I enjoy working for the Attorney General. We go about our business every day. We're accomplishing a lot of good things.
How's he holding up?
I think he's doing great, and you see him in the news every day, and he's doing well. But we're going to keep on working on the important matters. You know, from my perspective, the things I oversee, the divisions I oversee, do a lot of things that don't make the news every day, but are nonetheless important. Campus speech is just one of many, and I'm proud to be doing it.
All right. Well, thank you, all three of you, for coming here. We really appreciate it. And we are actually within our time, and so I'm moving to my notes of the end. Thank you to all the guests. Thank you to Washington Post Live. And I hope it was as fun for you all as it was for us.
Thank you.
Thank you, Ruth.
Thanks, Ruth.
Thank you for your moderation.
Thanks.
Thank you.
I meant to tell you, Jesse, we've had actually two now.